Let's fill out the Georgia General Power of Attorney together, the document that lets someone you trust handle your money and property. Start with you, the principal. Type your full legal name and where you live. Use your full legal name exactly as it appears on your ID, so there's no doubt who signed. Now name your agent, the person you're giving authority to. Here, Ben Carter, with their address. And name an alternate. Here, Carlos Diaz, in case your first choice can't serve, so your document doesn't stall if something happens. Now the powers. The form lists subjects, A through N. To give your agent authority over everything, initial the line in front of N. To grant only some, initial just those specific lines instead. Then choose when it takes effect. Here, effective immediately. One important thing, depending on your state, a general power of attorney may stop working if you become incapacitated. If you want it to keep working no matter what, ask about a durable power of attorney instead. Finally, print your name and date it. Sign it the way your state requires. We'll cover those exact rules in the recap. Then give a copy to your agent and to anyone they'll deal with, like your bank. First, the document needs to be signed by the principal, that's the person granting the authority. If the principal cannot sign themselves, another individual may sign on their behalf, but only in the principal's presence, and only at the principal's express direction. Next, you'll need one or more witnesses present. These witnesses must attest to the principal's actions, meaning they swear to or affirm what they observed. And here's an important detail. That attestation must happen in the presence of the principal, and also in the presence of each other. Now the document must also be notarized. All of those signatures and attestations, every single one, must be done in the presence of a notary public, or another individual authorized by law to administer oaths. Keep in mind, that notary or authorized individual cannot also serve as one of your witnesses. Once properly executed, the power of attorney is effective immediately, unless the principal specifies within the document that it becomes effective at a future date, or upon the occurrence of a future event or contingency. And one more thing. If the power of attorney involves real property, an original power of attorney must be used. Remember, this is general information, not legal or tax advice.